The great thing is we no longer have the ordinary purpose test. We no longer need to prove direct or indirect contribution. We no longer have to concern ourselves as to how often capital or income from the business was used for the benefit of the family, whether that tie clip was a personal gift or whether it was to impress corporate clients, whether the lakeside cottage that no one ever used because of the black flies factored into the long-term financial security of the family. Perhaps the most controversial distinction between Section 65 of the Family Relations Act and Section 95 of the Family Law Act is the constriction of judicial discretion to deviate from the presumption of equal division by raising the threshold of fairness. Under the Family Relations Act, equal division under Section 65 has to prevail unless it would be unfair, having regard to the criteria set out in that section. The Court of Appeal, in a 1989 decision, defined unfairness as being a situation where, quote, equality is offensive to a sense of fairness and justice, having regard to the circumstances of the parties. Section 95 of the Family Law Act creates a higher threshold by replacing the word unfair with the words significantly unfair. The words, or close to it, significantly unfair, has been considered, interestingly, in several cases, mostly dealing with disputes between strata owners and strata corporations. The Court of Appeal, in a decision called Reed, approved the definition of the trial judge, who defined significant unfairness as being burdensome, harsh, wrongful, lacking in probity or fair dealing, done in bad faith and or unjust, and inequitable. In Oberter, however, it was noted by the Court of Appeal where it was stated that in that particular case in Reed, that counsel on appeal had argued that significantly unfair had essentially the same purpose as oppressive or unfairly prejudicial. But the court held that it was unnecessary to determine whether there had to be an element of oppression under the test of significantly unfair. I anticipate, as many of you will share, I think, that the definition of significantly unfair under Section 95 of the Family Law Act will very likely be one of the first matters that comes before the Court of Appeal.
Finally, to wrap up, brings with it a whole new regime. There replaces our Section 56 four-part triggering events with the single triggering event under Section 81. Section 83 will help with respect to what constitutes date of separation, but you'll still have to refer back to the common law principles. Section 85 gives us an entirely new excluded property regime and provides some very specific classes as to what constitutes excluded property. The onus of proving excluded property is on the spouse seeking to exclude the property. Where property is excluded, it's only the increase in value between the date of the relationship or the marriage and the date of separation that is divisible. Section 96 provides the court with some limited jurisdiction to intervene if that is unfair. And finally, Section 87 finally gives us some parameters as to how valuation is supposed to incur, the key being that valuation date will now be the date of the trial.
Trust issues in the family law practice are not bread and butter everyday issues. But what I have found in my practice is that when I have had to deal with them, they're technical, they're confusing, they're difficult, and there's this relearning process every time the issue comes to you. Under the FLA, unfortunately, I think from one perspective we can say that the FLA simplifies and tries to reduce litigation and controversy relating to property division. I don't think I can say that with respect to how it deals with trust law issues. And so my hope is that, again, this isn't bread and butter, but by virtue of listening to this presentation and doing a little thinking yourself, when the issue comes up for you, you're not pulling your hair out thinking, I'm going crazy. It is confusing, it is difficult, and hopefully the presentation gives you some insight.
Now, you've all been told thousands of times, of course, that a trust is a relationship, not an entity. As a general rule, the consequence of that is the trust property belongs to the trustee, not to the beneficiaries. And that's something which, with greatest of respect to both the judges and counsel present, has not been reflected well in case law under the Family Relations Act. And by the look of it, initially at least, until changes are made, has not been well reflected in the legislation under the Family Law Act, and so that confusion may continue.